Everybody, is it working? Yeah, okay, let's start again. Good evening. Thank you so much for coming to this event. It's a real pleasure actually to welcome back Matthew Evans. We come full circle. So obviously I have to tell you this anecdote. The first PAS annual lecture was his brainchild when he was the managing solicitor at the Prisoners Advice Service, and he forgot that it was his partner's 40th birthday. So he very cleverly booked it on Julie's 40th birthday. So that was how she spent her 40th birthday. She is not here with us this evening. I want. So you've all got this thing on your chair, so you can read about Matt, who runs the AIRE Centre. That's only 2 years younger than Paz, and he's going to deliver the lecture this year, which is, as usual, inspiring, uplifting, full of promise, inspiring, revolutionary, not any of those things. But nonetheless, it will be interesting. And what we hope you'll take away from that is the need to keep protesting, because I'm not sure that there's a great deal more that we can do unless we all join the Conservative Party, stand for MPs and break them up from the inside. But until we do that, please welcome Matthew Evans, who is delivering the lecture on What About Our Human Rights?
Okay, so that slide is going to be up throughout the talk. There's no other slides. That's it. And I suppose it's designed to be slightly provocative. I'm certainly not suggesting, not yet anyway, that the UK mirrors Nazi Germany or Franco's Spain or Pinochet's Chile or Suharto's Indonesia. But like Nando's peri-peri sauce, fascism has different levels of heat, and how a country views the human rights of all of its population, and indeed migrants seeking to make the UK their home, is undoubtedly an indicator of where the direction of travel may be in relation to a country, and where it stands in relation to those kind of 14 tenets. So talking of fascism, the title of the lecture is actually taken from a 2007 Daily Mail article. Although we couldn't have known it at the time, it was arguably the golden age of journalism at the Mail, before they only ran headlines about beer and Currygate. The article made the now familiar claim that human rights law unfairly protects individuals as opposed to society as a whole, and called for a return to common sense. And we will see that phrase again. And a framework based not on rights, but on responsibilities. In short, human rights are not fundamental or universal. They're qualified by a person's participation within the norms of British society. And those who fall outside of those norms, either by virtue of their immigration status or criminal record, for instance, either no longer deserve human rights, or maybe indeed were never entitled to them in the first place. And the relationship between rights and responsibilities within the development of human rights laws has been hotly contested. And it's not my intention to examine theories behind that, or the ideas about whether or not human rights are inherent or should be legislated for. Instead, and within the time available, I want to track how we ended up where we are now. Content to break international law, a government pursuing policies like Rwanda, which seem to admit breaching the European Convention, and how politicians suggesting that the UK join Belarus and Russia as countries not party to the European Convention has become now normalized in day-to-day political debate. And within this is how certain groups and cases, such as prisoners, are used to weaponize this debate, and the idea of what are and their rights. So I've got to start somewhere, and the Human Rights Act seems as good a place as any, given that next year will mark its 25th anniversary, or would have, depending upon whether or not you think the new Bill of Rights has still got legislative legs. English public law before the Human Rights Act, if you believe those with false memory syndrome like Lord Sumption, was a land of dicey, the independent rule of law, the availability of remedies to all without fear or favour, the common law's protection of civil liberties, how great we were, how terrible the continent was, and all the rest of it. Forgotten or simply not cared about in these misty-eyed recollections of simpler, happier times were things like mass bail conditions imposed on picketing miners in breach of their right to liberty, and judges legitimising a series of miscarriages of justice. And at the time of the Human Rights Act, one of the many unlamented Home Secretaries, Jack Straw, and a significant reason why I ended up leaving the party for the first time, now third, for those keeping count, described the Act as a defining piece of legislation, a landmark which set the liberties we have long enjoyed in the United Kingdom onto a constitutional footing. He added, I believe that the 1998 Act will be seen as one of the great legal, constitutional, and social reforms of this government. This eulogy was welcome, not least because the Human Rights Act proposals had never seemed to occupy much of the hearts and minds of the new Labour government, even less so its Prime Minister, who in his first conference speech as PM in 1997, and foreshadowing the Daily Mail article 10 years later, said, "A decent society is not based on rights, it is based on duty, our duty to each other." And as a piece of constitutional reform, it had barely got a mention in Labour's 1997 manifesto. Although it had a nice new Labour catchy slogan, bringing rights home, the proposals were in fact buried in the section cleaning up politics, below the idea of how to reform party funding and elected mayors for London and other cities. My own personal recollection of the Human Rights Act was on its very first day it came into force. I queued up to issue and obviously got lost around the Bear Garden, a JR in respect of a case called Cornelia and Snaresbrook Crown Court. The case concerned a challenge to a hospital restriction order issued under the Mental Health Act. And we delayed issuing the claim for several days so that in part we could plead the Article 6 fair trial points. It was also noteworthy to this audience that Ed Fitzgerald QC, a PAS patron, was my instructed counsel, and Philip Sales, now a UK Supreme Court judge, was on the other, and should I say, losing side. The Human Rights Act was certainly not seen as a cause of celebration for all. The then Shadow Justice Secretary, Nick Herbert, penned a piece in the Telegraph titled "Human Rights Act, the law that has devalued your human rights," which is quite a tongue twister. He reflected that legislation has been a gift to lawyers, an encouragement for undeserving litigants, and a burden on frontline public services who struggle to decide what the law is in practice. This view, frequently expressed by the right-wing popular media, now runs like a golden thread for almost any political or public discourse on human rights law, and the need for reform and the role and legitimacy of foreign courts. It was also not long before the attitude of the Labour government towards their own act had become, to say the least, ambivalent, especially as the practical constraints that the legislation imposed on its fights against crime, the treatment of asylum seekers, and the so-called war on terrorism became apparent. Labour government ministers, in particular successive Home Secretaries and Lord Chancellors, made disparaging remarks about the Act. These were usually in relation to decisions of judges in individual cases. As early as 2003, following the decision requiring state support to be provided to destitute asylum seekers, David Blunkett, the unlamented Home Secretary of the day, stated he was personally fed up with having to deal with a situation where Parliament debates issues and judges overturn them. He seemed to have largely forgotten, though he would not be the last Home Secretary to do so, that the Human Rights Act actually controls judicial capacity, reaffirming the principle of parliamentary sovereignty in sections 3, 4, and 6, and it does no such thing as empower courts to strike down primary legislation. The events of 9/11, soon after the Act came into force, and the concern that the UK was facing unprecedented dangers brought into sharp focus the balance between national security and liberty. Following the London bombings in July 2005, Tony Blair declared, "Let no one be in any doubt, the rules of the game are changing." Speaking about the issue of deportation and diplomatic assurances, he indicated that should legal obstacles arise, we will legislate further, including, if necessary, amending the Human Rights Act in respect of its interpretation of the European Convention. Criticism of the Human Rights Act continued whenever a high-profile incident came up, such as the murder of Naomi Bryant by Anthony Rice following his release from prison on license, and the High Court's decision that 9 Afghani hijackers could not be deported to Afghanistan because they faced a real risk of torture or death there. Call Me Doctor John Reid, the unlamented Home Secretary of that day, described this decision as inexplicable or bizarre, and Tony Blair considered that it was an abuse of common sense, those words again, to be in a position where the government were unable to deport people who hijack a plane. He immediately called for a review of the legislation, asking for the Human Rights Act to be amended in order, as he said, to better strike the balance between the rights of the individuals and the rights of the community to basic security. In March 2009, Labour published a green paper entitled Rights and Responsibilities. The paper said though it had no intention to resolve from or weaken the Human Rights Act, a new Bill of Rights and Responsibilities would give prominence to responsibilities in addition to rights. Like the current Bill of Rights, what that meant in practice was sometimes difficult to pin down. On the one hand, it made clear that rights would not be contingent on the exercise of responsibilities. On the other, it stated it would be possible for a future Bill of Rights and Responsibilities to highlight the importance of factors such as the applicant's own behaviour and the importance of public safety and security. David Cameron, the Tory party, no doubt taking note of Labour government's cooling attitude towards their own legislation, shifted from arguing the repeal of the Human Rights Act to wanting a homegrown Bill of Rights, sensitive to what he described as Britain's legal inheritance and core values as a free nation, balancing rights and responsibilities whilst protecting the fundamental rights set out in the European Convention in clearer and more precise terms. Their proposals, like the current government's, seem to consist largely of protecting rights which a future government thought ought to be protected, or making it harder to extend them inappropriately and where they didn't much love the rights in any event. A case oft quoted in those days by Cameron in support of scrapping the Human Rights Act was the case of Liaco Cindamo, who was a young Italian citizen serving a life sentence for the murder of the teacher Philip Lawrence in 1995. An asylum and immigration tribunal had ruled that to deport him to Italy would breach his Article of Convention rights. The Daily Mail ran an article headlined, "When Human Rights Are an Insult to Us All." It called the decision a profoundly stupid and amoral ruling, and that we have, of course, seen many lunacies perpetrated in the name of human rights. Compensation for IRA terrorist families, prisoners allowed porn, preachers of hatred free to continue abusing our hospitality. I think that may have been a Paz case, the prisoners allowed porn. But this ruling stands in a grotesque league of its own. Like Theresa May and Catgate a few years later, the actual facts and why Article 8 protection was not only relevant but appropriate were simply ignored. Cameron himself described the ruling as complete madness. The fact that Cindamo had in fact been in the UK since he was 6 years old, spoke no Italian, had no connection to Italy other than his citizenship was beside the point. And the decision was far from mad, even if you thought the balance could have been tipped the other way. What I hope this little run through of the lead up to the Human Rights Act shows is that the Human Rights Act has been undermined at every stage, subject to the whims and outrages of press and politicians alike, where reforms are constantly called for and needed in order to restore the supremacy of the UK courts and parliament from foreign laws and courts. But despite all this, and all previous attempts to scrap the Human Rights Act, it had got little attraction until now, that is. And so on June the 22nd this year, the government has laid out its Bill of Rights bill before Parliament. Dominic Raab, the hopefully soon to be former and unlamented Justice Secretary, told the press that it will curb abuses of the system and re-inject a healthy dose of common sense, those words again, by strengthening traditional UK rights, such as freedom of speech, under attack from expanding privacy law to stifling political correctness. It's noteworthy that when he talked about freedom of speech, he was actually more interested in the ability of the Daily Mail to say what they wanted than any freedom of speech to say otherwise. The bill had its own inglorious consultation history, which is worth briefly looking at, given that it shows that these reforms have never really been about improving the law, but are driven by ideology, and as I, like much of the court-based legislation that's come through from this court, basically to avoid scrutiny and accountability. The government set up, handpicking the panel members and drafting their terms of reference, an independent Human Rights Act review. On the very same day that the panel published their report, the Ministry of Justice published their consultation on human rights reform. As well as a primary school level analysis of Marx and the idea of negative obligation, and a discussion about anti-vaxxers' favourite pieces of law, such as the Magna Carta, though sadly not the Nuremberg laws, this whole document was founded on a decision to replace the Human Rights Act with the Bill of Rights. This was something not even considered by the panel in its 423-page report, not least because it hadn't been part of their terms of reference to begin with, and nor, as they noted, was there actually any depth of support for one in the thousands of pages of responses from NGOs, legal experts, politicians, the President of the European Court, and members of the public. So looking at the bill, the first thing to say about the Bill of Rights is how appallingly drafted it is. The second thing to say is that the government's arguments that this will strengthen, not weaken, human rights in the UK simply do not hold water. The bill projects a veneer of continuity that is completely superficial. Raab has emphasised that the UK intended to remain a state party to the European Convention. However, that is merely paying lip service to the system, given that the bill itself proposes substantially decoupling the UK's domestic human rights regime from the Strasbourg system. As a number of commentators have also cautioned, the bill will result in the UK being in breach of its obligations under the European Convention more often, making it more vulnerable to adverse rulings by the court. The question then becomes, how will the UK respond to such adverse judgments? Prisoner voting, which I will touch on later, already gives a big clue, but the consultation document itself explicitly stated that the UK simply does not intend to comply with adverse European Court judgments when it doesn't wish to do so. That is despite Article 1 of the Convention requiring state parties to secure to everyone in their jurisdiction the rights and freedoms set out in the Convention, and Article 46, which requires states to abide by the final judgment of the European Court in any case to which they are parties. Moving on to Clause 2, this confirms that the bill gives effect to the same set of Convention rights as the Human Rights Act. However, although the catalogue of rights to be given domestic effect remains unchanged, the bill gives effect to those rights in different and insignificant respects in a much lesser way than the Human Rights Act. As a couple of examples, although domestic courts will continue to be able to make declarations of incompatibility when they find domestic legislation incompatible with convention rights, it is not clear that the government will actually take any remedial action as regards such declarations. The bill also limits domestic courts' powers to read convention rights generously, reducing again the likelihood and circumstances in which incompatibility may be found and potentially declared. Finally, although Clause 12 maintains the duty of public authorities, including the government itself, to act compatibly with convention rights as set out in Section 6 of the Human Rights Act, this has to be seen in the context of domestic courts having less scope to interpret convention rights generously, and the duty contained in the bill will also yield when public authorities are required by primary legislation to act incompatibly with convention rights, and when they act to give effect to or enforce legislative provisions that are incompatible with convention rights. The bill also sets out a number of explicit changes, which, as it puts it, are designed to take back control. First of these is removing the duty on courts contained in Section 3 of the Act to interpret legislation compatibly with convention rights, and it simply doesn't replace it with anything comparable. It also removes the duty on courts to consider how the European Court has interpreted a right and limits any interpretation to a literal reading of the text, the aim being to ensure that any domestic courts interpret convention rights in only a narrow and very conservative fashion. It prohibits courts from finding a public body owes a positive obligation, and which would require the public body to take certain steps to actively protect, fulfill, or facilitate rights. And we will look at the ways in which the human rights has been instrumental in challenging some institutionalized failings later. It also requires courts to give great weight to the views of Parliament when balancing rights issues. Clause 7 requires courts, when deciding incompatibility questions, to treat Parliament, by having enacted the relevant legislation, as having decided that the Act already strikes an appropriate balance between the relevant competing factors. There's also some judicial micromanagement in areas where the government simply doesn't like the case law. So Clause 8, for instance, will prevent domestic courts from finding legislative provisions concerning deportation to be incompatible with the Article 8 rights and the right for family and private life, unless the provision would require the relevant person to be treated in a way that would occasion harm so extreme that it would override the otherwise paramount public interest in removal from the UK. This simply doesn't accord with Strasbourg case law in Article 8, and again will result in the UK courts either being obliged to rule that legislative provisions concerning deportation are compatible with the European Convention, even when they are in fact incompatible. So what the bill actually ends up doing is not giving back control to the UK courts at all. Instead, it seeks to wrest control from courts generally, not just the European Court. The European Court is straightforwardly marginalised by the bill, but the bill will also, and it should not be in any doubt, marginalise domestic courts in a variety of ways. So I want to look at some areas where the effect of the Human Rights Act has been criticised, spoiler alert, misrepresented, and where some of those critics seek to argue a Bill of Rights would remedy its myriad faults. The first broad area of criticism is that human rights somehow undermines public safety by making the fight against crime and terrorism harder. So one of the most controversial decisions of the Strasbourg court in a case called Charhol versus UK, which decided that there is an absolute prohibition on torture, inhuman and degrading treatment, so that a state cannot deport a person to a country where they fear a real risk of torture, regardless of how high a security risk they pose to the UK. It led John Reid to regret his government had ever introduced the Human Rights Act. However, the first thing to say about the judgment is, that contrary to what Mr. Reid suggested, it's not actually attributable directly to the Human Rights Act, because Charhol actually predates the Human Rights Act and is simply an example of the Strasbourg court directly interpreting Article 3 of the European Convention. It is instead an example of the European Court overreaching and interfering in matters which democracies are perfectly able to deal with themselves. The Charhol judgment actually only prevents a government from taking into account the threat posed by a particular individual in a relatively small number of cases. Additionally, the judges in Charhol were also not oblivious to how all this might look. The absolute nature of Article 3 seemingly to afford more protection to the non-national applicant who's been found guilty of terrorist-related crimes than to the protection of the community as a whole from terrorist violence. However, as the court emphasised, states are not allowed to combat international terrorism at all costs. They must not resort to methods which undermine the very values they seek to protect. And this applies the more to those absolute rights from which no derogation may be made, even in times of emergency. And this is reminiscent of an oft-quoted judgment given by President Barak in the Israeli Supreme Court, when he declared that the violent interrogation of a suspected terrorist was not lawful, even if doing so may save human life by preventing impending terrorist acts. His words are worth repeating because governments tend to not want to confront the complexities and realities of what democracy truly means, or the role that courts have in upholding the rule of law and constraining government actions where they breach it. And that's irrespective of whatever electoral mandate they have. As President Barak said, this is the fate of democracy, as not all means are acceptable to it, and not all methods employed by its enemies are open to it. Sometimes a democracy must fight with one hand tied behind its back. Nevertheless, it has the upper hand, preserving the rule of law and the recognition of individual liberties constitutes an important component of its understanding of security. At the end of the day, they strengthen its spirit and strength and allow it to overcome its difficulties. The UK courts have also undertaken similar balancing exercise as regards the rights of majority versus individual rights. In the Belmarsh 9 case, a group of non-UK nationals who had not been charged with any criminal offences would have been detained following 9/11 under legislation which allowed a derogation from Article 5 in exceptional circumstances, challenged their continued detention. The House of Lords, as then was, said that the conditions for derogating from Article 5 had been met, namely in their view that the events of 9/11 constituted a public emergency, threatening the life of the British nation, although Lord Hoffman dissented. However, the measures were unlawful on the facts, given that the government had provided no evidence that they actually addressed the security threat, and the fact that they were disproportionate and discriminatory, unjustifiably differentiating between non-UK citizens and UK citizens on the grounds simply of nationality. Lord Bingham, who gave the lead judgment, said it brought into sharp focus once again the acute tension that exists between the urgent need to protect the public from attack by terrorists and the fundamental rights of the individual. The Belmarsh 9 case also highlighted the misnomer that somehow adverse judgments always tie a government's hands legislatively. Because even in this case, and where the law lords had issued a declaration of incompatibility, quashing the derogation order, the government all that the government was simply required to do was to go away and think again, which they did. introducing control orders as a happy alternative way to restrict civil liberties. Another expressed concern is that human rights should be decided at national level and not by a supranational court manned by judges from 47 countries. The Human Rights Act, its critics argue, incorporates the European Convention into domestic law and thereby means that the UK courts are no longer free to make their own judgments as regard convention rights, instead having to slavishly follow the decisions of foreign judges. This is another legal rabbit hole, as national courts are not always bound to follow where Strasbourg leads. First, the obligation of our courts when interpreting the convention is to do no more than take account of any relevant Strasbourg jurisprudence. Section 2 and 3 of the Human Rights Act already allow a degree of flexibility in this regard. Secondly, although the domestic courts are required to take account of Strasbourg jurisprudence, in a case which involves the application of principles which are clearly established, it can also decline to follow a decision of the European Court. And there's a case called R versus Horncastle concerning the UK's procedural rules for admitting hearsay evidence in criminal trials and their compatibility with Article 6 and the right to fair hearing, which is an example of this. Similarly, the European and national courts will often engage in constructive dialogue to resolve differences. And again, an example of this is the Grand Chamber decision in Vintner in UK, which expressly disagreed with domestic judicial findings on whole life sentences. The matter was revisited by the Court of Appeal in McLaughlin, who criticised the lack of understanding of the domestic law and affirmed that domestic law did in fact protect Article 3 rights in question, a decision which was subsequently affirmed by the European Court itself in Hutchinson in UK. And finally, the Strasbourg Court itself recognises the fact that human rights are national at a level of application through the inbuilt doctrine of the margin of appreciation. And before the Rwanda removal case became the cause célèbre of everything that was wrong with the European Court, there was, of course, prisoner voting, an idea which made David Cameron physically sick. And I think is this about their 15th time the prisoner voting has been the subject of an annual lecture? But anyway, let's go for it again. So in Hearst versus United Kingdom, the margin of appreciation took centre stage. As we're all aware, not least from the last 15 Basel annual lectures, Hearst decided that the blanket ban imposed by the UK on the right to vote of all prisoners serving a sentence of imprisonment breached Article 3 of the First Protocol. These rights were not absolute, and so the court agreed that there was a margin of appreciation in this area, which was in fact wide. And the court also accepted that a ban on prisoner voting potentially pursued a legitimate aim. However, the UK's total ban amounted to, in the court's words, a general, automatic and indiscriminate restriction on a vitally important convention right, and therefore fell outside of any acceptable margin of appreciation. The decision caused a furore, but meant that PAS annual lectures had lots of stuff to talk about. The European Court had decided, after all, that all prisoners, no matter what the offence sentence, had the right to vote, and the UK would have to lump it. Except, of course, it said no such thing and had no such consequences. What the court actually said was that it was left to the UK as a member state to devise a proportionate scheme which complied with the judgment. It was not for their court to draft a legislative scheme to remedy the problem any more than it would have been for the UK domestic court to do so either. And what the government did was to largely ignore the ruling for 10 years, other than drafting and dropping a bill to look at the issue, while using the case to continually demonise judges in Strasbourg as interfering in UK democracy. The other thing that Hearst should have put an end to was the myth of Strasbourg supremacism, namely what the European Court says goes, or as Lord Roger of Earlsbury put it in Secretary of State for the Home Department versus AF, albeit he said it in Latin. I never did Latin. Strasbourg has spoken, the case is closed. But if that were true, then prisoners would not have had to wait until 2017 for a compromise, which even then only allowed a vote in very limited circumstances. Nor would it have allowed the UK Supreme Court itself in Chester to refuse to even issue a declaration of incompatibility so as to put pressure on the government to allow such votes. The final general concern which has been expressed about the Act is that it's caused authorities to act in a risk-averse and sometimes ridiculous manner. This is linked to the idea that the Human Rights Act has unleashed a culture of grievance, encouraging woke people to make frivolous claims which overburden the taxpayer and line the pockets of self-interested fat cat lawyers. Lubia, I'm looking directly at you. The Bill of Rights prohibition on courts finding that a public body owes a positive obligation is a misconceived reaction to these ideas. And I'm sure that there are examples of public bodies making stupid decisions under the banner of the Human Rights Act or the European Convention. I'm also sure that the vast majority of those decisions are based on a misinterpretation of what the Human Rights actually requires them to do. And it's hardly a sensible reason for getting rid of the Human Rights Act or introducing a Bill of Rights, much less abandoning the Convention. Instead, it's probably a good reason for educating public authorities to act wisely and with a proper understanding of the law. But what the Human Rights Act has undoubtedly done is allowed individuals to challenge institutional failings by public authorities. After all, it was the Human Rights Act that prompted the Mid-Staffordshire public inquiry concerning high mortality rates at Staffordshire General Hospital and the patients receiving appalling care, which resulted in wide-ranging reforms to the NHS. It was the Human Rights Act that meant police must follow up on rape claims after police were found to have not taken allegations against John Walboys seriously. It was the Human Rights Act that was instrumental to a case which the AIRE Centre was involved in, and where the UK Supreme Court ruled that twin sisters with learning disabilities who were looked after but who were not free to leave the homes they were in had suffered a loss of liberty. As Brenda Hale put it, a gilded cage is still a cage. And it's thanks to the Human Rights Act that there are now regular reviews to ensure that the best interests and needs of disabled people in care are looked after. It was the Human Rights Act that allowed the family of a young man serving 90 days in a youth offender institution for theft, and who was brutally killed by his cellmate in a racially motivated attack on the day of his release, to secure a full public inquiry into institutional and individual failings in the prison service. So, drawing on some of these concluding threads together, it's easy enough to see why someone like Paul Dacre is hostile to the promotion of Article 8 and the right to privacy at the expense of Article 10 and freedom of expression. The exposure of the seamy side of lives of several celebrities, after all, sells newspapers. It's also not difficult to see why a politician who suffers a reverse in the courts in a human rights court case may blame human rights law rather than him or herself or the department for his or her defeat. However, their hurty feelings, in their own words, should not mean watering down human rights protections for the rest of us. Is the Human Rights Act fit for purpose? Yes. It's a well-drafted piece of legislation, and who could argue with the rights it sets out? Not even apparently this government, which, as we've seen, catalogues all of these rights into its own Bill of Rights. Is there need for a Bill of Rights? Possibly. There are certainly arguments that the range of rights protected by the Human Rights Act are restricted, giving effect to a limited and outdated range of human rights which are contained in the Convention, which obviously is 70 years old now. A Bill of Rights could introduce new rights, such as the right to culture, language, identity, adequate standard of living, the right to social security. It could do all of those things. Does the current Bill of Rights do this? Of course not. It doesn't even do what it says it's going to do. It diminishes human rights protections and will likely result in more application to and UK losses in the Strasbourg court. The government will then either have to accept this, exploding the myth of a UK free of foreign court interference, or defy them, thereby breaching international law on a regular basis. What about Strasbourg? It's certainly not immune to criticism, given the delays and backlogs. It's like all courts, it tends to be cautious and conservative, and nor all of its judgments perfect, far from it. And there are also legitimate issues around how the margin of appreciation of a member state is sometimes interpreted. However, we shouldn't make the mistake of thinking that our courts are always better. They're simply not. And a good example of a case where Strasbourg was more in tune with, in fact, UK public opinion than our own courts was in the case of Smith, which concerned the lawfulness of the policy of excluding gay people from the armed forces. The European Court has also been instrumental in strengthening the UK law in other areas, such as its development of law on the investigation into deaths and the interpretation of the right to life under Article 2. And leaving the convention would also have obvious consequences to other international treaties to which the UK is a party, not least the Good Friday Agreement and Brexit treaties. And finally, and taking us back to the beginning of this talk, what about rights and responsibilities? We can debate if the UK is a democracy, in the same way that we can debate if it is heading towards a form of fascism. But what is clear is that we want to live in a democracy, that individual liberties have to be held for the rule of law to mean anything. This is even where those individual liberties require an uncomfortable balancing exercise vis-a-vis the rights of other groups and society as a whole. The convention, which was born out of the most terrible moment in history, was drafted in the way it was because people are different, outside of the norms of society, and those people are always the first to have their human rights extinguished. Organisations like the Prison Advice Service understand that only too well, and that is why they thoroughly deserve our support. Thank you very much.
Thank you very much, Matthew. I never call you Matthew, do I? Thank you very much, Matt. That was really interesting. I'm not going to do a long spiel. In fact, I'll hand over to Martine to do a thank you, etc. It's really cozy this evening.
I'm really grateful, Matt, for something so nicely informative and thorough. Because I'm not a lawyer anyway, I'd like something very simple to find out which of our present rights are really threatened by Dominic Raab's grounding of rights. If it's a silly question, you can tell me, I won't mind.
This is an impromptu Q&A.
Okay.
It wasn't on the agenda.
I know, it wasn't on the agenda.
They do. There you go.
Well, the most obvious rights are, I suppose, those where individuals would like to challenge public institutions, including the government itself. So the desire to, for instance, remove the positive obligations and not to allow the courts to look at positive obligations of public authorities in terms of what they do would be quite a significant step. One's only going to look at various cases, for instance, like Osman in UK, where it's the positive obligations around what the police should or should not have done in relation to a threat that had been made to a particular individual that led to a breach of Article 2. So essentially, the positive obligations mean to say that authorities just can't simply go, well, what are we supposed to do about it? And similarly, positive obligations in relation to victims of trafficking has been a significant development in relation to that area of law. But the short answer is that they are very keen to get rid of any rights which, as I say, threaten their accountability. What they seem to be very keen on is the idea of freedom of speech, but they're not very keen on freedom of speech in relation to the right to peaceful protest, but they are very keen to ensure that, for instance, people don't sue because they're upset about Twitter, as if this was the most important thing that was happening to the UK or to the world right now. Somebody, I know, Louis, can barely, yeah. Yes.
My question is simply this. The crucial practice parole process is that likely to strengthen or undermine the rights of
Do you want to answer that, Louis?
Undermine.
Yeah. To be fair, sadly, I don't work at the prison advice service anymore, and like lots of institutional knowledge, literally the day you leave, you literally forget everything about it. But what I do know, for instance, about the parole board is that the parole board users group are so peeved at these proposals that they are now, or have now suspended their collaboration with the parole board and the Ministry of Justice. And the other thing that I'm acutely aware of is the fact that, unlike criminal law barristers, rates for prison law are not going up anytime soon, and nor have they gone up in the last 20 years. And that is also going to undermine the ability of people in prison to get parole, because I think there are now less than 500 firms that do prison law as a specialism. 200. Yeah, down from 1,000 that used to do it. Yeah. And the prison population is not going down. So it's not, yeah. So it's not kind of, they're not going, well, actually, because the prison population is now down to 1,500, therefore you don't really need prison law anymore.
Maybe slightly linked, and I don't know if you can answer for it. So, yeah, just the point about protest. So we work with quite a lot of the community, and aside from the sort of complex technicalities of arguments, there was a really obvious question about practical economy. They're already we see groups where normally post-defensive would go on remand, they go straight in. There's a lot of questions coming up about, you know, the predictability of those conflicts around 10 and 11, if and when the act comes through, and what the actual practical effect, you know, you know, sentences are looking like 51 to 10 years, and obviously the challenge is
well, I mean, the issue about the kind of right to protest, one is that seemingly it seems to be largely driven by Steve Bray shouting at politicians about Brexit. He seems to be the main focus of all of this, and apparently now has his own police escort who follow him around all the time. But maybe on a kind of more serious issue, I mean, the talk talked about the fact that current government ministers are not alone in historically having always reacted to individual cases which they don't like. These are often cases which they don't even know about. They're simply reading in the Daily Mail or the Telegraph or the Express. And the right to protest and how the government deals with that is undoubtedly a reaction to, for instance, juries saying in relation to Stanford, well, actually, you know, we don't really care what the law is. We think these people have a legitimate right to protest, and we're going to find them not guilty. And so the government is just simply always looking to try and squeeze out how much the courts or the court systems can ever move away from rights that they want to restrict. Yes.
I was going to say, picking up on what Mike Gilboa said, what about the Secretary of State, the person who does the risk assessment for patients?
Yeah. I mean how that in essence falls within, doesn't fall within Article 6, and the right to a fair trial is anybody's guess, really. But again, you know, Article 6 on right to fair trial is one of those convention rights which the Bill of Rights is really not very keen on, to say the least. I mean, it's sometimes difficult, really, when you talk about the Bill of Rights in terms of what its real effect might have above and beyond some of the tensions that it will bring about, because actually it's so badly drafted that actually it's really got almost no substance to it. I mean, it's you know, like many things that the government does, you know, it simply takes previous legislation, so Human Rights Act, it just catalogues those rights. He just literally dumps them into the Bill of Rights and says, well, actually, you know, these are the rights that we're talking about. You know, we're not actually going to bother to really think about whether or not we're going to add any rights, or whether or not some of these rights and how they're interpreted might be looked at. They just simply dump a batch of stuff in, and then look around ways in which essentially they can squeeze out interpretations which they don't like. And squeeze out areas where they think, for instance, the deportation cases, where they think actually, you know, we don't like a batch of cases that we may or may not have heard about, but we're going to legislate for it anyway. I mean, anybody who thinks that pleading an Article 8 human rights case is easy in a deportation appeal has never undertaken a deportation appeal and has never had to plead it before an immigration judge. I mean, it has been restricted and restricted and restricted to the point where, you know, lots of lawyers talk about almost the impossibility of arguing a pure Article 8 case in relation to deportation. But the government doesn't accept that. The government accept that its job is already done. It simply wants to kind of make it even more impossible, and to be seen to be making it even more possible, which is its only real purpose.
What's going to happen now that
Well, I think they're all gonna, yeah, I mean, I think they're all definitely gonna be bumped off to the summer. And it's difficult to know what a new Tory administration would think about it. I mean, certainly I won't use the word something fest, suggests that not much is going to change in terms of Tory hardline policies. I mean, I think all of them have committed to maintaining the Rwanda removals. None of them, I mean, some of them have suggested that they wouldn't leave the European Convention. I think Penny Mordaunt has. There's still, oh, is she out now? Yes, of course she is. Yeah, of course, Just Trust. Well, Liz Truss definitely will. I suspect Rishi, I don't know what about Rishi Sunak. Yeah, I mean, he's more worried about his non-dom status, so I suspect he'll be more interested in that. But yeah, it's difficult to know. But certainly, I wouldn't expect much to be done between now and when they come back in, whatever it is, September, October. And whether or not the Bill of Rights, depends if Raab is still there, depends if Patel is still there, whether or not that's something that's high on their agenda. Maybe they're plummeting in the polls. It's going to make them focus on cost of living standards, yeah, rather than these kind of culture wars and calling people woke the whole time. Marty.
Doing that, this is probably out of your any human rights. Sharon was for the past 5 minutes. The amount of time one can spend on remand in prison. 1 year, it seems. I can't send her to the sentence. Is there anything there?
Well, I don't know what the Article 5 case law is on that, but I suspect it's not great. Yeah.
I mean, I currently have women on remand who have been waiting 2 years for their trial.
But I mean, COVID was just a classic example of this idea of our rights and other people's rights. Whilst everybody had a debate about lockdown and visits and everything else, there were very few voices in opposition to the fact that prisons essentially pretty much stopped all legal and social visits, and that went on throughout the whole period, which was just outrageous. And like lots of these things, there would be individual challenges, and the government would just simply pick them off by making an exception and allowing visits in certain circumstances, whilst maintaining the kind of main body of policy. Well, Nikki, I'll give you the last question. Hooray!
Amazing bench for a mixture of the so-called bogeyman and direct action who sat in the road outside to stop people getting out. You have to just look at his A31 by somebody on there are, but whoever they are, the fact that prisoners advice services is small. I know we like to tell ourselves that, natural and PRT and how we do it on actually
And that seems the perfect point at which
And in a further uplift to the depression here this evening, drinks and nibbles outside. So do hang around for a little bit, have a chat, ask Matt any more questions. And I'll see, thank you so much for coming.
7 days notice.
No, key performance indicator of 20 days. Thank you again so much for coming. It's really, really nice that so many of you braved the heat and came to this event. Thank you to you all.